SJC-11999 and SJC-12004, James Green v. Commonwealth.
Good morning, Ms. Murray.
Good morning, and may it please the Court. Mary Murray for the Commonwealth. The trial judge, in all cases, is required to give jury instructions that are full, fair, complete, and clear. They have to be correct. And the cab limiting instruction given here was neither correct nor a fair statement of the law, because there was not only error, as the appeals court said in Sousa just last year, but here there was also prejudice. The prejudice is that it prevented the Commonwealth's evidence being fully considered. As the petitioner concedes in his brief, the Commonwealth offered expert opinion from 2 qualified experts, but the instruction given, which is similar but actually more egregious and prejudicial than the one deemed inappropriate, inadvisable, not a fair statement of the law, and confusing at best by the appeals court in Sousa. The instruction here was actually worse because it required the jury to not only credit the qualified examiner, but to credit specific components of her opinion, specifically her opinion as to mental condition and her opinion as to risk of reoffense.
Is your argument basically that, I mean, isn't what frames this sort of how far does Johnstone go?
Well, Johnstone told us how far it went.
Well, I mean, but isn't that it seems to me that's where the rub is that whether it really is truly gatekeeper or whether the QEs play a role in the trial itself. Right?
Well, in Johnstone, as a matter of statutory construction, this court said that in order for the Commonwealth to proceed to trial, it must have the positive opinion of at least one of the 2 qualified examiners that the person remains sexually dangerous, and the court also noted that it would apply to initial commitment cases. We had that here, and as Mr. Nam Crane graciously concedes in his brief, Dr. Connolly was eminently qualified and offered a well-detailed, well-supported opinion. So there was no challenge, for example, to her credentials. There was no challenge to the admissibility of her opinion. And once the Commonwealth has offered that, the directed verdict motion, by the way, was denied, and properly so. The Commonwealth is not limited, as this court said in Cowan and in Blake, to presenting evidence only from the qualified examiners. So once expert evidence is in, as this court has said going back decades in this area of the law and countless others, once that evidence is in, it is for the fact finder to weigh and credit it.
Okay, but let's examine that. I mean, I take your point that Johnstone did not consider this issue because Johnstone simply said that the evidence is insufficient as a matter of law unless at least one QE says the person is sexually dangerous.
Right. It was a directed verdict, actually.
But if you look to what Johnstone says, it says that the reason why it reached that conclusion, which Johnstone recognized was not explicitly addressed in the statute, is that the evidence would not be sufficient as a matter of law if it rested solely on the testimony of the person in that case, and in this case, who was the CAB expert.
Right.
So the judge essentially says, and I gather this was a collectively designed instruction by those who do the SDP cases. I gather Judge Kottmeyer was involved. Somewhere I read that this had been the instruction they had put together collectively.
Judge
Judge McLeod
also
said it on the record when she was standing in for Judge Pierce, but I'm also aware of that because I was one of the people who contributed some of the proposed instructions to the judges when they were putting them together, and that's noted in the model jury instructions.
And I gather that the reasoning is, if the evidence is insufficient, if it rests solely on the CAB expert, then if the jury were to say, we do not credit the testimony of the QE, then they are resting their finding solely on the CAB expert, and that is not in keeping with the spirit of Johnstone, even though Johnstone never reached that point.
Well, not entirely, because the other qualified examiner in this case, for example, concluded that he did have a statutorily defined personality disorder. So you could easily see them crediting her testimony as to mental condition and drawing the other, they could have, even if we were going to go with that interpretation, which I suggest is wrong, based on this court's own subsequent decision in Blake. But even if we were going to go with that, the other qualified examiner in this case opined that Mr. Green had a mental condition as defined by the statute as a personality disorder. Both, she determined it was a clinical personality disorder, that in his experience of it comported with the statutory definition of a mental condition, a personality disorder, which are separately defined.
But remind me, the second QE, his ultimate opinion was that he wasn't sexually dangerous, right?
Her conclusion was, although he had a mental condition at this time because of his experience in treatment and his age, she did not think he met the likely piece of it. But you certainly could have drawn, as a reasonable juror, from her conclusion that that Mr. Green had a mental condition. And this instruction struck right at the nub of it. I would point out that right before Johnstone was argued, this court decided Cowan, in which it determined that the fact finder is not limited to only the expert opinion from a qualified examiner. And when the argument in Cowan was that the trial judge should have placed very little weight on the opinion of the probable cause expert who was testifying at that initial commitment trial, this court rejected it. Johnstone was argued 1 month later, ironically, the same week as the Blake case. Johnstone was decided April 2009. 3 months later, this court decided Blake, which had been argued 3 days before Johnstone, and reiterated and reaffirmed the holding of Cowan, that how much evidence to give in an SDP case, how much weight to give expert opinion, comes from, is for the fact finder. So once the expert is in, then it is for the jury to weigh it all together. Simply to say you have to credit this specific piece flies in the face of decades of rulings of this court.
In fairness, the challenged instruction said you may find support for the opinion anywhere in the evidence.
Right, but you have to credit this specific piece and this other specific piece of her opinion. Now, when you're evaluating evidence,
Okay, so you're, I take your point with regard to the other QE. Arguably, they could have found that that QE opined with regard to the mental condition part. But it's your position then that if the jury were to find that I reject the opinion of all the QEs and with regard to their conclusion or their opinion that the defendant is sexually dangerous, that a jury may still find the person SDP.
yes, because when you're evaluating evidence, to parse it out in that manner is not a fair statement of the law. Yes, because in this case, there was no challenge to the expertise of Dr. Johnson to give expert opinion. In fact, as it's clear in the record, she is herself a qualified examiner, but was acting as a member of the board. The petitioner concedes she was a qualified expert. So although the court has said as a matter of statutory construction, not a matter of Constitution. The Constitution doesn't demand qualified examiners versus some other expert. It requires expert opinion on the mental condition sufficient to reach all the elements beyond a reasonable doubt. But the instruction as given is hopelessly confusing when you consider it in the light of the instructions as a whole. You can credit all, none or some, as was given in the preliminary expert instruction at the beginning of the charge. But in order to meet its burden, you have to get here. To construe Johnstone the way the petitioner and the way the Superior Court construes it, the way the petitioner is arguing, means that the court is functionally saying, you can offer all the other experts you want, but the only ones the jury can rely on is the qualified examiners. That would be rewriting the statute in a manner inconsistent.
Wasn't that what Johnstone essentially, Johnstone certainly says you can, if the Commonwealth can offer all the experts it wants, but unless one of them is a QE who is opining that the person's sexually dangerous, it's insufficient.
And that's the gatekeeper function, absolutely.
You're saying essentially Johnstone should be limited only to the issue of the sufficiency of the evidence and should have no bearing on whether the jury rests their determination solely on the CAB expert.
Right. They can draw from all the experts, and in fact, in many cases, in this one in particular, you can have an expert opining that the person has the requisite mental condition. Oftentimes, that's not even a dispute. In this case, it was hotly contested, which is why the argument, why the instruction is so prejudicial. The standard of review here, when we consider that it was not only error but prejudicial, and we're not writing on a blank slate, because even after Johnstone, in the opinion by Justice Botsford and Santos, the court talked about, although it wasn't deciding specifically the expert issue, talked about when considering whether petitioner's expert reports come in under the statute, that it's a matter of fairness because you wouldn't be able to contest the expert opinion coming from the CAB and the qualified examiners if they couldn't offer their written reports into evidence. So when you look at all of it, and the statute says the legislature has designed the Community Access Board, mandated it to conduct reviews of sexual dangerousness, which this court has said time and again is a matter for expert, not lay opinion.
And I take it that as you note, the CAB member who testified, indeed, as it turns out, is a qualified examiner, just as it wasn't designated as one of the qualified examiners in this case.
And there was no challenge at trial to her opinion or her ability to deliver an expert opinion, to form an expert opinion, and more importantly, Mr. Nam Crane graciously concedes in his brief that she was a qualified expert.
But that doesn't mean that she would meet the test under Johnstone as far as the QE testimony that you needed to have.
The Commonwealth had that here, however, through Dr. Connolly.
I understand that, but I'm saying if you didn't, she would not meet that. Even though
Not
she had
acting, right, under the current statute, which has been interpreted by this court in Johnstone, that is correct. We would have to offer the affirmative opinion. And the opinion, there was no challenge to the admissibility of Dr. Connolly's opinion, to the sufficiency of her opinion, and the judge denied, the trial judge, Judge Pierce, correctly denied the directed verdict motion, and there's been no suggestion that that wasn't proper.
So do you agree that if there is only one qualified examiner who is of the view that the defendant remains sexually dangerous, that that qualified examiner must testify at the trial?
That issue has never arisen, but ordinarily I would expect that the opinion would come in, or if for some reason the person were unavailable for some reason, then either you would ask for the case to be postponed so you could have another qualified examiner designated, or you would see if the report could come in lieu of the direct testimony.
But you're not saying, I take it you're not conceding at least the possibility that maybe the qualified examiner never has to testify.
Well, that issue hasn't come up, so I can't envision the circumstance in which it would.
But you're not saying that either that the gatekeeper function of the qualified examiners is satisfied once at least one qualified examiner opens the gate, and once the gate is opened, it is open forever.
No, because I think that in order to proceed to trial, you have to have that opinion. The opinion has to be admissible, so assuming there's no defect. For example, in Felt, this court excluded a qualified examiner from testifying because she had disobeyed a court order or not complied with a court order to let the attorney be present during the interview. So that opinion was excluded. I take it the Commonwealth couldn't have relied on that. But the ordinary process is that the qualified examiner would be expected to testify, to be subject to cross-examination. If that qualified examiner were to withdraw the opinion in the middle of the trial, for example, if suppose the petitioner, it had turned out, would have been diagnosed with some disease that was sort of expected to be fatal in a short period of time that would cause a change of opinion. We've had that happen shortly before trial, and when the opinions have been withdrawn, we notify the court with an affidavit or if the court wants a hearing, but the qualified examiner has to retain the opinion. So if it were withdrawn in the middle of the trial, then we would no longer have sufficient evidence to survive the directed verdict motion. But assuming the qualified examiner testifies, assuming the qualified examiner's opinion is admitted, and there's nothing that changes the opinion, for example, the disclosure of some serious medical condition or other event that would cause the examiner, the qualified examiner, to retract her opinion, then that gatekeeper function is satisfied, and there's none of that here. There was no withdrawal of the opinion, there was no challenge to the admissibility or the credentials. And since I see that the time is about to expire, I would draw the court's attention to the Commonwealth's brief on the matter of the stay. And unless there are any questions on that matter, the Commonwealth will rest on its brief, except to note at the single justice argument, Justice Botsford, you had asked a question about Mr. Green's participation in treatment, and I'm prepared to address that if the court would like to hear it.
Sure.
You had asked if he was in a particular class, Pathways 5, and I looked into that matter. It was recommended that he's been maintained on the same unit. It was recommended that he take another preliminary class before that on sexual interests. And he had originally not been doing treatment, then he was doing treatment but not wanting to address his own issues, more recently doing that, and he's now in that other preliminary class, which is what you had inquired at.
Thank you, thank you.
Mr. Chief Justice, Justices of the Court, Michael Nom Crane for the petitioner. I think that if you look at the Johnstone case, there's sort of two holdings. And the question is, which is the horse and which is the cart? Because at first, it starts off with the holding that, and the court says we hold that this is not so, and that is that the cab member report and testimony are sufficient to meet the Commonwealth's burden at trial. And then what I would say is the corollary really is what's being pulled along by that theory is that there's this concept of a gatekeeper. But that gatekeeper, even when you first talk about the holding, the gatekeeper has always been understood to be that role at trial.
Well, isn't that the question, though? I mean, is the gatekeeper the person, or the people, but one person, who allows the trial to happen, but once, as Justice Spina said, the gate is open, then the trial, like most trials, the jury gets to decide who it believes and who it doesn't believe, in whole or in part.
Well,
I mean, isn't that the question we have to answer?
Exactly, Your Honor. And I think my answer would be this. In Johnstone, you talk about some fundamental concepts. One is that the need to have somebody with expertise to talk about a mental condition that drives behavior. We need to have an expert. And that expert is required, so he's required by substantive due process. That expert has been designated by the legislature to be the qualified examiner. So that qualified examiner not only has like a legislative significance, it's sort of holding the integrity of the whole substantive due process need to have expert testimony.
Well, I mean, that may be true if that was the only evidence, but isn't the question not whether there's an expert, or it's what can the jury do with a plethora of experts?
In this case, and this probably goes more to the prejudice of even if you find that this instruction is error, the jury is very thoroughly instructed as to how much autonomy they have, and they pretty much have complete autonomy as to how they look at all the evidence, how they weigh it, what they reject, what they accept, who they believe, who they don't. And that goes for all the exhibits and all the witnesses, including the experts. And that was told to them at the beginning of the trial and at the end of the trial. This instruction itself, as Justice McLeod was trying to say, that she and Justice Kottmeyer, and I'm sure other justices working on this with the help of the Department of Correction and others, they were trying to form an instruction that would reflect the strong statement by the SJC in Johnstone that these QEs have a central importance and that they're a gatekeeper. And they didn't want to minimize that gatekeeper role. And I said, and I think we need to be careful that yes, there's a gatekeeper, but they shouldn't be just a ticket. There's a difference between being a gatekeeper and a ticket. Is this a ticket for the Commonwealth to get into trial, or is this a person that's going to ensure that the trial is consistent with the statute and is done reliably, that we can rely on the results?
But what's the point? I take it one of the things that's happened, or the issue here, is whether or not the jury, well, the gatekeeper becomes an additional element to the analysis. The jury essentially is being required to conclude that the gatekeeper function was properly satisfied. So it's like a second look at the gatekeeper function, and that becomes an element of the Commonwealth's proof.
Well,
And is that really necessary?
I wouldn't characterize it as an element, Your Honor, because the way this instruction is written, all it does is make sure that this piece of, this operative witness, this important piece of evidence that has to be present under Johnstone at the trial is at least reliable. That is, that you can credit it.
But you're getting two qualified professionals that are going to get up and testify, presumably for the Commonwealth, that the petitioner is currently sexually dangerous, and you know, going through the steps of the elements of what it means to be sexually dangerous. Why isn't that enough?
Well, because I would say in most cases, other than these cases, really, the judiciary is the gatekeeper. In expert testimony, they decide under Lanigan, is this person a reliable person? That role, that judicial role, has been taken away by statute with these cases. So there isn't anybody, as people like yourselves, who can look at the expert testimony and say, is this reliable? Is it even believable? And that's taken away. That expert has to be admitted, has to be accepted as a witness.
But in a more conventional setting, a judge makes a decision under, after conducting a hearing under Commonwealth versus Lanigan, and says that the person is reliable.
Right.
Do we ask the jury again to revisit the judge's decision?
Well, there is a case, I think Justice Lenk wrote about Higgins, where there was a question about the judge instructing on sort of Dalbert sort of principles. But that's not necessary to instruct the jury, and it may not even be a good idea. But when you don't have, when the judiciary realizes that this witness is a gatekeeper, has a central role in the process, and yet their ability that they would normally have in every other case to make sure that it comes before the jury as a reliable piece of evidence has been taken away, then what they can still do is at least put forth to the jury in keeping with Johnstone and making sure that, the Chief Justice says, the spirit of Johnstone is upheld, that this witness who has to be there, who's absolutely necessary, is an essential element of evidentiary, of expert evidence, is at least reliable. That they're not like presenting a divining rod or something like that. So that the jury, so that then the government can't just present another witness who they're really relying on, where they might have a very weak and sort of uncredible.
Isn't the instruction more than saying it's reliable? You have to credit this witness,
well, that's
and in
what
particular,
that's
you
what
have to credit these pieces of the witness's testimony?
Well, that's what I take that term to credit, meaning, I take the word credit, not to like accept them like beyond a reasonable doubt, but just that you can, that they become a preliminary fact, that they're just, something that's believable. So like, for instance, in the Young case that is attached to Ms. Murray's pleadings, in that case, they gave, and there wasn't really any discussion about the error of that, other than that it was not an error. The instruction in that case is basically the same here as in Green, where the judge said, as far as the two qualified examiners, you don't have to believe either one of them beyond a reasonable doubt. You can use other evidence in the case to corroborate their testimony. If you don't believe them at all, either one of them, then you may not find that petitioner sexually dangerous. So that's a Young case also trying to enforce Johnstone, saying, if you can't find these people believable, then they become a straw man. They become a sort of a nullity, and they supplant the role, the cab then supplants their role as being the sole evidence that the Commonwealth is moving
Is
forward
Young
on.
an appeals court case?
That was, the Young case that's in page 41 of my
128, I
appendix.
think, isn't it?
Excuse me?
It's a 128, isn't it?
Yes, exactly.
Can I
Yes.
just focus your attention on something you've raised about the gatekeeper function, which I think, I understand how it informs your conclusion. Do you think that a judge in these circumstances, if you had, for example, hypothetically, looked at this particular QE, the one that went forward to trial, and looked at the report and said, wait a minute, there's more than a typo here. Obviously, there was a typo in her report. the whole premise is an assumption that it was going under one theory of the mental condition required, and it was wrong. You would at that point, could you at that point ask for voir dire of the premise before going to trial and say, Judge, in your function, this is just wrong?
I think that has been tried by some of my brothers and sisters who litigate these cases. But again, we don't consider Lanigan in these cases. These people's, their testimony, whatever it might be, is admissible. And, you know, like for instance, there are certain diagnoses that aren't necessarily in the DSM, like paraphilia NOS and hebophilia and stuff like that, which there's a huge amount of controversy over, and a lot of experts don't really think that it's a thing that should be driving these cases. But that doesn't stop experts in this Commonwealth from testifying that that is what they believe the mental condition is.
Is this instruction that different from a med-mal case instruction, which tells the jury that if you're to find for the plaintiff, you must at least credit the opinion of the expert, because without expert testimony, you can't find for the plaintiff?
I think it's very similar to medical, because medical malpractice, this is another unique area of law where you sort of have to, certain elements have to be found by an expert. And they're also told in those instructions that you're free to, you know, not believe the expert if you don't think, like, for instance, the facts that they're testifying to are true, or whatever the reasons you don't believe them. But if you are going to find this element, you know, it has to be supported by the expert's opinion.
But
But
if there
here
were
it's
three
saying
experts?
it's saying, it's not just saying you have to rely on expert testimony, you have to rely on this expert, and in fact, you got to rely on what she said here and here.
No, I disagree with that interpretation. It's not, and I think it's specifically crafted not to say that, because I think this, and it may be poorly worded, but I think what this instruction is trying to say, and I think it does say logically, is that you don't have to rely on this expert, because you can find evidence in other parts of the evidence, but you at least have to credit this, like you believe what they are saying. You find this person a credible witness. You don't have to necessarily accept that this is the right mental condition or something like that, but you have to at least find that this person is creditworthy. This is you find that this is reliable. You're not totally disregarding what they're
How's the
saying.
jury,
And it's sort of I know it's
that's
sort of,
taking to a philosophical or epistemological level that I don't know.
well, I think it's there because the judge can't do it, because there's no Daubert, there's no Lanigan. The judge can't say, no, this expert's opinion has no support in the community, et cetera, you're not, you're not coming in. They can't do that. So he's at least telling the jury, do you have sort of similar problems? Can you at least credit this person? And I mean, credit is sort of maybe less an inexact term. I think actually the Young instruction might be technically better, because what they're saying is you don't have to find beyond a reasonable doubt using these witnesses. You can look at anywhere in the record to get that. But if you don't believe them at all, then the government can't move forward. And that may be a better instruction. But I think this is what McLeod and Kottmeyer were trying to say.
Am I wrong in assuming that, for the most part, if not always, the CAB expert has not interviewed the petitioner?
There are situations where a person will interview with the CAB board.
Okay, so I take it, I'm sort of thinking out loud more than anything right now, I take it there is some advantage to calling a jury's attention to the fact that they must accept the qualified expert's testimony, or the qualified examiner's testimony, because the qualified examiner, I take it, at least has had the opportunity, may not have actually interviewed the defendant, but may have had a better opportunity to interview the defendant than a CAB member.
Right. I mean, the QEs are much more focused on the task at hand. They do a deeper analysis. It's not by vote, where you have sort of this, I would argue, group bias maybe going on. And it's important to look at the regulations too. When those CAB people are voting, they can't abstain, they can't change their vote, and if the superintendent has a problem with what with what's going on, and they think there's something missing, something important that needs to be added under the regulation, they could say, I want you to consider this piece of information too. So it's a highly controlled situation by the Department of Correction, whereas a QE is this independent operator who's following what is in the industry, the standard modality of doing an analysis. They use the actuarial, they look at the risk factors, they look at the studies, they talk to the person, and they look at all their records. There is studies that actually show that kind of analysis, especially with the actuarial element to it, is a much more reliable way to go.
If the CAB member has had an opportunity to interview the petitioner, can the CAB member take a different view than he or she did at the meeting?
Well, that's a good question, because again, they can't change their vote. I guess if
When they testify, you mean?
when they testify, I mean, I don't know how that affects the regulation, because the regulation says they can't change their vote.
Well, they're not changing their vote, they're testifying.
They're testifying, but if they were to testify to something they didn't vote on, I don't know.
Do they have to vote? Do they have to testify in accordance with their vote?
Again, it's a good question, because they can't change it under the regulation. I mean, they're free people.
When they testify, are they expressing an opinion or communicating how they voted?
Well, it's sort of this hybrid. They are experts. I mean, they're qualified examiners, so they're testifying about expert concepts, and they're applying their expertise and explaining things to the jury in an expert capacity. But in the end, they're really projecting the majority opinion of the CAB board.
You wouldn't, I mean, I take it the Commonwealth would not put on a minority member of the CAB board to testify?
No, I think that they might have in the past.
Really? To say what?
Because there's been majority opinions where they found a person not SPP and it might be a minority.
Oh, all right, but we're saying the same thing. I mean,
Yeah, yeah.
but they wouldn't put on somebody who didn't agree with the idea that this
we would
person
put
was
the
still an
minority on.
SPP.
Yeah, we would put the minority. Yeah,
right.
certainly, and I know that's been done.
All right, thank you.
Thank you very much.